Cool. So now your question. So the first question is so it's a tenant that lives in an apartment or a house and the geysers burst. Now, or the geysers hasn't necessarily burst, but it malfunctioned. And it's under warranty, it's being repaired, maybe it's by insurance, but whatever the case is, landlord's taking care of it. Unfortunately, the defective geyser has caused damage in the sense that some utility was unfortunately overused. So either it was water that just kept running and now there's a massive water bill, or maybe electricity just kept heating water and just never stopped. Whatever the case is, the tenant complains that this is a very, very high utility bill as a result of the defective geyser. Can he claim this from the landlord?
Perfect. So just to deal with geysers quickly. So obviously geysers are something very common, depending on the type of property that you're using, but certainly in every residential circumstance, you're going to see some form of geyser in there, and landlord is responsible if this thing bursts. And generally, like it's in terms of this question, there's an insurance or a warranty or something that's going to cover that geyser. So generally, the landlord's got something like this covered. The question here really relates to, well, who is the landlord's now covering the geyser, but who's liable for the resulting additional costs as a result of that geyser faulting? And in terms of this question, what the writer says is that their bill is usually about 700 Rand per month, but during this period, there was a bill of about 3,000 Rand per month as a result of the water or the electricity issues. Okay, so the first difficulty I really have with something like this is it's easy enough to go, well, these are two numbers, but to try and proportion that out to, well, who is that completely on the landlord side because there's been a burst, or do you guys share this proportionally in the circumstances? That's a difficult question. I certainly don't think the tenant can just go, well, I've got an average and that whole amount must be on the landlord. That's not really how it's going to work in the circumstances. And there are a lot of questions that we don't have in respect of this particular question. So the first thing is, there's presumably in this case a lease agreement between the parties, and most substantive lease agreements that are concluded between parties are going to have some level of provisions with regards to tenant notifying the landlord of any damages that occur on the premises. So something like a burst geyser, generally these things give some level of warning sign that something has gone wrong in the circumstances, be it a reduction in water pressure or water coming through the roof. And there's generally an obligation on the tenant to mitigate that damage, certainly in terms of any lease agreement, but also then notify the landlord as quickly as possible so that the problem can get sorted out and there's not an accumulation of damages in the circumstances. And unfortunately, in terms of this question, we don't have that, the lease agreement and any provisions relating thereto, but we haven't also been provided with time periods. Is this 3,000 Rand over 2-month period, or was this an immediate burst and dump of water in the circumstances? Those things are going to matter on how we proportion what damages happened in the circumstances. So look, as legal enforcement goes, this is one of those tricky proportional sort of questions in the circumstances. You're certainly going to have difficulty saying that the landlord is completely liable for all of this in the circumstances, depending on the facts of the case. What I would suggest doing, again, this is one of those circumstances where practicality needs to overcome legality, because you're not going to go, even if we take the numbers as they've been presented to us, you're never going to go to the court to enforce it's going to be a 2,300 Rand claim. It's simply not a viable option for you. The Rental Housing Tribunal might be an option, and I'm not exactly sure how they'd go on an issue like this, but obviously they could make a determination in these particular circumstances. But it might be worth, and one of those circumstances, again, where we say, don't go approach your attorney first thing. have the conversation with your landlord. Maybe there can be some reprieve, which the landlord is willing to work with you on, and that might be the best way to sort it out in the circumstances. Legally enforcing, even just from a practicality side, just from a cost side, absolutely not. By the time your attorney writes a letter and opens a file and goes through the documents, I can guarantee they would have charged more in legal fees than the disputable amount of 2,000 Rand in the circumstances. So certainly, can you legally enforce it? I wouldn't even bother in the circumstances.
Absolutely. Cool. And then the next one is actually going to be quite a simple question. If a lease agreement provides for the payment by a tenant of utilities, as per consumption, and up until now, there's never been any prepaid meters, but now recently prepaid meters have been installed, can I as an agent or I as a landlord now basically tell the tenant, listen, sorry, you need to buy your own water, there's the meter, pay for it, and you've got rights of utilization. Is that permissible?
Perfect. So obviously a very normal clause in terms of a lease agreement, which is concluded between a landlord and a tenant, is the tenant is liable for their use of utilities in respect of a particular premises. And in respect of a complex situation, either that's going to be, often what happens is there's either a separate meter, which is serviceable to a particular unit, and that's how the water or electricity charges are given to a particular landlord, or in some of the older complexes that have been established, there might be a proportional split of any utilities that are utilized in respect to the premises, which is usually based on the participation quota within that scheme. So you have a certain percentage of the full scheme, call it 10%. So you are one of 10 units on a particular scheme, and they're going to proportion 10% of the electricity to your particular unit. We are moving away from that. More and more complexes are doing individualized meters now because there are some resounding, difficulties which can happen with a proportional representation system. But be that as it may, these are normal systems for doing it. And as we see in this question, this is a complex which utilized the proportional system, then is moving on to a individualized meter system. This is also very common nowadays, and it's rolling out with lots of complexes. Now, in a circumstance like this, obviously we're going from one way of billing into another way of billing, and the question here is, well, is that permissible if in circumstances where there's a lease which was already in place under the old system of billing? And in this particular circumstance, we're given a clause in terms of the lease agreement, which does actually allow for the use of individual meters. So on the facts that we have in terms of this particular question, it's already catered for in terms of the lease agreement. The landlord is absolutely entitled to go, well, now an individualized meter has been installed. So that is how we're progressing from here on through the lease agreement. And in any event, you couldn't progress in any other way because you're not going to be doing a participation sort of system anymore. You're only going to have metered utilities in the circumstance. So absolutely, you can proceed. And even if there wasn't a clause, if that is how the utilities are now being provided to the scheme, and provided, of course, your tenant is liable for the utilities. There are rare occasions where, for instance, utilities are included in the rental amount, which would change the answer to this particular question. But if they are liable to pay the utilities, there's absolutely no problem switching them over as the system switches for the scheme and as the billing system changes in the circumstances. So in terms of this, even though there's a lease agreement, the lease agreement was concluded before, no problem. You can start providing the metered accounts.
Thanks so much, Nick.
Perfect. Thanks, Bruno, and we'll see you next week.
Cool, cheers.
Bye.